Welcome everyone to today's episode, the fourth in our webinar series on Investment Mediation Insights. Glad you joined us again. I see on the list of participants some recurring names, and welcome to those who joined us for the first time. Let me start out to just recall that a couple of weeks ago we did publish our working paper number 6, which is the final working paper, and the newest news is that the vote on ICSID's amendment package, including on the mediation rule, is scheduled for the first few months of 2022. Needless to say that even before the rules are formally adopted by our member states, they are available for parties to agree to and have ICSID administer the mediation, which is already happening in practice. Let me first highlight again shortly the other mediation initiatives that we are conducting at ICSID. You will have seen our mediation papers. One is a background paper on investment mediation, and one is a treaty analysis on mediation provisions in bilateral and multilateral investment treaties. We've also supported our colleagues at the UNCITRAL Secretariat in the preparation on the notes of mediation as a tool to settle investment disputes, that in the context, of course, of the investment dispute settlement reform and the working group number 3. We've published a series of blogs with our friends at Kluwer on investment mediation about the suitability, how to assess suitability of mediation for a given dispute, when mediation might be used in the context of an investment dispute, chronology, and differences between mediation and conciliation at ICSID. Of course, what I want to underline here is our upcoming Investor State Mediator training that we will hold on January 19 to 21. And Damon will put a link in the chat for the application should you be interested in joining our course. Now, of course, turning to this webinar and the fourth episode in the series, we'll be talking to Wolf von Kumberg and Martin Wolfbauer. I'm really pleased to have you here. We have two experienced in-house counsel who have participated in mediations from the investor perspective and will share practical insights. The whole idea of our webinar series is to really provide information on how investment mediation looks in practice. More biographical information on our accomplished panelists is available on our website. You will have seen it when you registered it. And one more note on the format before we start. I welcome all participants to ask questions and put them in the chat. We'll pick them up in the course of our informal conversation or at the end where we see it fits best. So with that little introduction, let's dive right in. Wolf, Martin, as an investor and in-house counsel, have you actually successfully negotiated settlement directly without mediation? Let's start out with a broad foundation on that. Who wants to go first?
Well, let me kick that off. Thank you very much, Frauke, for inviting me to be here today. And thank you to the participants for joining us today. Hopefully you will get a better flavor for this developing area of investor-state mediation. So just a little bit of background. I spent more than 25 years as in-house counsel for a number of aerospace technology companies responsible for the legal affairs outside of the Americas, so really covering the rest of the world. Much of my activity was actually dealing with our disputes. One of the tasks that I had was really to deal with the states. We typically had contracts either directly with states or with state agencies, so we dealt with states frequently. With respect to issues that arose with states or even disputes, I would say that states are quite capable and amenable to negotiating with investors. But there are caveats to that. And of course, as we go through this afternoon, we'll talk a little bit more about some of the obstacles of negotiating with states. But one of the key ones to remember is that a investor-state situation is very different than a pure commercial situation for investors, because the state has a lot of other considerations when it's dealing with a commercial matter, and that is there are political considerations, of course. There are social considerations, and there are just the considerations that have to do with the general investment climate in a particular country and the encouragement of foreign direct investment in that country. And so dealing with a particular investor, it plays into a lot of those other considerations as well. The other aspect I think that I would raise here is the fact that it very much depends on the state. Some states are very well equipped to deal with negotiations, with disputes. They have an internal structure that's quite clear. There's a process that's to be followed in those situations, and the state officials know what it is that they can do or who is responsible for doing certain things. Other states aren't organized that way. It's perhaps more chaotic. They don't have a formal structure whereby they have the ability to not only negotiate, but also to enter into settlement agreements. And in those situations, it's of course more difficult to actually come to a satisfactory conclusion through negotiation. And so I think it really is, there are a lot of different considerations when you are negotiating with states, but just to summarize, certainly we had very many successful negotiations with states, and states were willing to enter into agreements to resolve issues with us as an investor. Martin, perhaps your view on that.
Good morning and good afternoon, wherever you are, and thank you for being here to share my experience. Also a little bit to my background. I'm now for more than 12 years in the international legal department of a major construction group. And the construction industry, by its nature, I was almost to say, on a regular basis, unfortunately, sees once in a while disputes. And the employer of construction companies are also on a regular basis public employers. And this is the link to states. As Wolf mentioned, it could be the state itself or certain agencies responsible for construction projects, road projects, infrastructure, whatsoever. And yes, it happens in these disputes that you need to negotiate as you would do with commercial private employers. And as Wolf mentioned already, it can be challenging if you need to get someone on board in case of a dispute that who is able to negotiate on the one hand, and secondly, and this I think is connected to the negotiation capacity, is also able to settle, so that these people do have the power to negotiate and to settle. And I fully agree, it depends very much how structured a state or public employer is in this respect to deal with dispute situations. I think the one thing is when you do have a project in a certain country where on a regular contractual basis you do have issues you can resolve within the limit of your contract or contractual regime. But as soon as the dispute gets bigger and more crucial, you need to have someone on board from your contractual partner, and in this respect from your public employer and the state, who is capable and experienced in dealing with these disputes, to have a competent partner on board. And this is, I think, my main experience of the last years wherever you have someone and some organization in the state or the public employer who knows how to deal with these disputes, makes life easier and easier to come to a conclusion of settling a dispute.
Thank you. Thank you to you both for sort of sharing your insights on the practical aspects. And to add here, I think I've mentioned it in our last webinar as well. The World Bank statistics are that only a fraction of investment disputes actually end up in investment arbitration. About 6% is their calculation. And from what you shared here, that seems to support that, that there is a lot of direct negotiation and successful direct negotiation, and that's linked to state organization and structures, policies, and for our alumni and those who have joined our first episode, we've talked to Alejandro Caballo Leda from the Energy Charter Secretariat, who has done a lot of research on that as well. Again, moving on to the mediation aspect of this. So why would an investor then choose mediation over direct negotiations, and what are the benefits of doing so from your perspective?
Well, if I might just start with my thoughts and observations I had so far, I would say direct negotiations are quite close to your day-to-day life. But at a certain stage, when the dispute gets bigger, it's getting more complicated, one. And secondly, you would like to have someone in a certain process, namely mediation, who knows that this is now really meant to lead to potentially to a settlement. And in this respect, mediation could and should start instead of negotiation when you see things are not moving forward. And then I think it can be a more efficient and more structured way to solve a dispute. While direct negotiations could be a very informal meetings, but sometimes I experienced neither party was really structured and prepared as would have been needed in order to lead to a settlement, while mediation by itself and by its nature and as I think it's intended already considers before it gets started to structure this process in a way that you potentially get into a discussion where you more likely lead to a settlement and solving the dispute.
So at one point, the inclusion of a third-party neutral may be really helpful to jumpstart or ignite already discussions. Wolf, what are your thoughts?
Yeah, no, I think that's absolutely right, Martin. I think the process design aspect of it is extremely important, and the mediator or the neutral can certainly assist in helping the parties to create the right atmosphere for the negotiation to take place. And a mediation is really a facilitated negotiation, so it's still a negotiation, but it's a negotiation from a slightly different perspective. When parties negotiate directly with each other, it's very positional because each of them has a view of their position, their rights, and particularly the lawyers will be arguing on behalf of their clients with respect to what they feel the legal position is with respect to their party. Whereas mediation is really what we call principled negotiation, which means that what the mediator is assisting the parties to do is move away from simply looking at their rights, which obviously in an arbitration, the arbitrators will ultimately decide, to looking at what is it that the parties really need? What is it? What's their objective at the end of the day? What are they trying to reach here? The mediator tries to determine with the parties, either in joint discussions with them or in private discussions with them, what it is that would satisfy their real requirements or their needs. And so you get a completely different type of discussion that takes place with the help of a neutral, which then can lead to a resolution that the parties determine themselves rather than getting a third-party tribunal to make that decision for them. And so it's a very powerful type of process, mediation, and it's often successful because of the fact that the parties achieve what they need and agree to it themselves.
Mm-hmm. Let me pick up and underline two aspects of what you just said. Is the difference on mediation is that this forward-looking approach, right? Not what happened in the past, which measure, which action breached what legal norm, but to say, okay, we are here, we need to look at the past, but where do we want to go from here? And either it is a continuation of the relationship, or perhaps, both parties agree to terminate the relationship, but want to manage how that termination would look. Would you agree with that sort of approach, Wolf?
Yes, absolutely. That's absolutely right, Frauke. And as you say, I mean, the solution might be to agree the termination. But again, the powerful aspect of it is that the parties themselves agree the terms then of that termination rather than a tribunal making that decision for you. And I think you always get a much more satisfactory result if you yourself have had a role in making that decision. And so you get a better settlement, I think, out of it.
Mm-hmm. If we stay on that for just a second, I just listened to a podcast by the Center of Effective Dispute Resolution, CEDAR, who actually published that in online mediation, which has happened more during the pandemic, the settlement rates are even higher than they were before, around 85% now. Is that, Wolf, you are an experienced mediator as well. Is that sort of a ballpark that you think is realistic?
I think it's extremely realistic. I think because of the pandemic and there will be different, of course, effects depending on the industry. But I think people are much more pragmatic right now in finding a resolution to the dispute because everybody questions, what the future will look like. And if you have a traditional dispute that might take 2-3 years before it's finally resolved through an award, it's much better to try to find a resolution now. And I think that's what parties are realizing. So I agree with that figure. That's probably quite accurate.
And Martin, I listened to a talk from one of your colleagues talking about mediation in pandemic, and it sounds like in your experience on the pandemic side and mediation, that's sort of similar. Would you agree with that?
To be honest, not necessarily.
Mm-hmm.
I could not say that over the last 2 years I've seen an increasing willingness to settle. It's really, maybe it's also the industry I'm much more focusing on, but it's really about getting things solved. Whether there's an epidemic or lockdowns, people do not really care. It's really about the matter itself. So I'm not able to confirm this observation.
Mm-hmm. And the operational focus, right, on dispute settlement to move forward. And I think that's really helpful to underline that aspect of investment activities, really. But from your experience, at what stage do you see mediation happening? If we look at sort of a chronology, investment establishment, then a problem arises and you have more meeting that develops into a grievance, and the timeline may continue. What do you think, either of you may start, when would mediation be likely to happen the most?
Well, maybe Martin, if I could just start that. I mean, that's always a question. I mean, even in a normal commercial situation, not necessarily investor state, that there's always a question about when is the right time to do it. There's a big debate, and there has been for many years, when drafting disputes clauses as to whether you have a stepped clause which calls for negotiation and then failing that mediation, failing that arbitration or litigation, whether that's actually appropriate because perhaps the mediation step comes too early and it's not really the right time for it yet. So there's a debate about that, and I won't get into that. But mediation, and this is just, I'm talking now from my own experience and the way I've seen it utilized, and as a mediator that mediates these types of disputes, I would say that disputes that are resolved at an earlier stage, particularly where the parties have a relationship, and this is an important aspect because, of course, that's not always the case. As you were saying, I mean, sometimes we're talking about expropriation, we're talking about termination of that relationship. There isn't going to be an ongoing relationship. But where there is an ongoing relationship and the potential of salvaging that relationship and dealing with the issues that have arisen at an earlier stage, you actually have a better opportunity to resolve it because the parties haven't become intractable in their positions. They haven't really hardened their positions to the point where they simply will not compromise. And so I would say that in those situations where you do want a relationship to continue, and just thinking of an investor state situation where it's not an expropriation type situation, but rather where maybe terms of the concession agreement have to be discussed. Dealing with that at an earlier stage will probably lead to a better outcome. So that's what I would say. But Martin, you may have a different view, particularly from your own construction experience.
Thank you. I noted down when I was thinking about when is the right time to start mediation, I noted down not too early. But this is not in contradiction to what you said. I think why I was thinking about like not too early is that people, probably on both sides, on state sides, but also on investor side, need to fully understand the dispute. They need to fully understand the facts. They need to understand their legal entitlements, if any, and to which extent. Because I do see on a regular basis that, and which I think is a natural process, when you are a party in general and you think that you're entitled, is that you maybe have not thought everything to the very end. And if you still think that you have a certain entitlement and the other party is sure that you don't have it, even with mediation, you won't come to a solution, because when you step then too early in the mediation process, decision makers could say, yeah, but the mediation does not lead to what I do expect to get out of the mediation, to get from the other party, to get from a settlement. And therefore, now let's go to arbitration. Let's go to the final court's decision-making process. But, and this is the big but, is, as you, Wolf, mentioned earlier, it's very important to have a roadmap for mediation that is understood by the parties. One, I think, and I've seen this on several cases, when we have dispute clauses in contracts, which foresee mediation, I would say to 80% people saying, oh my God, we have to go to mediation before we are entitled to go to court. This was like a burden for people having this mediation clause in. Two things to that. Maybe mediation clauses is difficult in contracts when it doesn't fit to real life at the very dispute. And secondly, I think it's important that people involved in contractual relationships and in relationships with states on both sides do understand what mediation means, that this can be a very effective tool if it's properly set up. And then I'm coming back to what you mentioned, Wolf. At an early stage, it makes sense because their relationship might not be completely destroyed. There's still connections where people can sit together and speak to each other. But for that, this is my experience, and this would be my recommendation when I would be asked, is to yes, do mediation at the earlier stage, but then really think about what do you need to get through this mediation process to, at the end, being ready on both sides to settle the case or to agree whatever you're looking for. And this includes really the objectives. What is the objective? you want to get out of the mediation. This needs to be known by both parties before they step into the mediation.
Thank you both for your contributions here. It's super interesting, and I think it links back also to what we said originally, right? Both parties need to be ready, and that may depend on the internal organization. They need to know what is it that they want to achieve, and that may change over time. Maybe not early on, but once you are in an arbitration, you've seen all the facts, you've saw your case and the strengths and the weaknesses, to reassess perhaps at a later time when mediation might come into play. One choice doesn't exclude the other. And that leads pretty naturally to my next question, which is, how do you prepare for an investment mediation as counsel? And how is that different? Martin, I know you especially have been counsel in investment arbitrations. How is that different from the investor state arbitration context, pleadings, hearings, and all of that?
Thank you. I think there's a very important question and topic to be considered. How to prepare for investment disputes, and this includes mediation. And for mediation, as I mentioned before, it's important that the investor, meaning management, responsible and in charge for negotiating and going into mediation discussions, and settling authority, do have a good, meaning a full understanding of the dispute, the merits of the case. So you need also legal advice. You need to understand what are you entitled to and to what not. And that's, for example, what we are doing. We are really advising internally our operative management. Okay, here you have entitlement, but here this is a very weak point, so don't build on that. So that maybe when you in a certain contractual relationship, you on site or on the project think, yes, we are fully entitled, then it's very important for an internal counsel and internal advisors to neutrally inform management, which is then supposed to go into a mediation process where they are realistically, and without any false and wrong expectations. And this is sometimes a hard process. And this is, again, the preparation for mediation, to really digest maybe the expectation that someone might have from the beginning of a project, including the new dispute that just arose, and then to come to the situation, yes, now I, as the responsible representative of the investor, do fully understand the case. And only, I would say, with that knowledge, expectation management, a realistic one, someone should go into a mediation process. Because I think only then someone, an investor, would be ready and able to reasonably engage in mediation discussions.
Thank you. Thank you for pulling that out, that the legal analysis, right? Wolf mentioned facilitated negotiation is mediation. What is it that the parties want to get out of it? Where do they want to travel to in these discussions? That doesn't mean that the law and the analysis of what are the contractual obligations and the contractual situations, as you well set out, lose their value in that sense. And to underline, the exact same approach was by the World Bank's investment climate work on the investment grievance management mechanism, to have that analysis of the dispute. Who are the players? Where are we? How strong or how weak are different cases? So that is also done on the other side for the states. Wolf, I know you actually have taught this, how to prepare for a mediation, an investment mediation. So we look forward to hearing your views.
Thank you. Well, it's, I mean, mediation advocacy, so teaching lawyers, both in-house and the outside lawyers, how to prepare for mediation is something that is important, because, lawyers generally are trained to deal with the arbitration process, but not about mediation. I mean, it's simply just something that is developing, and so most lawyers haven't had the experience of actually looking at their role in through slightly different lenses, because the mediation process, as we already discussed, is different. Martin put it very well, and that is, you have to understand the strengths and weaknesses of your own case. And obviously there will be strengths, there will be weaknesses in every case, and a very frank evaluation of that by the lawyers is important before you go into mediation, because that will be part of what the mediator is also discussing with the parties, and really testing them as to how strong their legal position actually is. But the other aspect, and you know, we always advise the lawyers to sit down with their clients to develop a negotiation strategy and put together a negotiation plan for the mediation, and really prioritize for themselves what are our needs, what do we really want to get out of this mediation, what are you know, the most important aspects, what are the less important aspects that we might be able to trade off with the other party, and why is it that we're seeking this position, what are the arguments that we will make to support our position on these points, and why we're making those points, because often parties don't really go into the mediation fully understanding what their objective is. And so it's just sitting back and discussing that with their lawyers allows them to really come up with a strategy. And that's going to be very effective, particularly if the other party hasn't done that. And how do we use the mediator? Because the mediator is there as a neutral, and the mediator's role is a very persuasive role with respect to the parties and the different positions the parties are taking. So how can we utilize the mediator to get our message across to the other party? And all of that is part of the pre-mediation planning. And the more of that you can do with your counsel, and the more that you understand what your objectives are and prioritizing them, the better the outcome will be for you. Because at the end of the day, that's what you're trying to do, of course, is get the best outcome that you can through that settlement agreement. And there's nothing wrong with having that view, but it's understanding how you get there as well. So I would say, Frauke, that's an important part of the planning.
And that's what you outline, where the mediator meets with the parties at the outset to review initial written statements, like brief overviews of what is it that's wanted to achieve, and the mediator can work with each party individually first to prepare the mediation, meaning joint session, or like a meeting over 1, 2, 3 days. That's what you had in mind, Wolf, right?
Correct. Yeah, absolutely. So the process is built then around that, and as you say, Frauke, typically you would start with a joint meeting of all the parties for them to express their views to each other. So, you know, maybe they're just repeating what's already known, but it allows them to do that again in a different kind of a process and different kind of atmosphere. And then the parties typically will meet individually with the mediator. And don't forget, the other part we haven't really stated here is this is a confidential process. Everything that's discussed with the mediator, it's agreed by the parties beforehand that this is a confidential process. And that allows the parties to be able to discuss with the mediator in private sessions things that they might not want the other party to know about, but the mediator has to maintain confidence and not reveal it either unless they have expressed permission to do so. So that's a very powerful part of the process, is that confidentiality. Of course, and Frauke, you'll remind me that in investor-state situations, often there's a bit of a conflict between transparency and confidentiality. And this is one of the aspects that has to be worked out in the process design with the parties beforehand to get a clear understanding of how much confidentiality is to be preserved and to what extent this has to be a transparent process.
So what you identified is, on the one hand, sort of the internal confidentiality with the mediator. The mediator is not judging, so parties can freely share, and he or she can, or they may disclose information to the other upon express consent. And on the other hand, what information and when and how is shared to people outside of the process. And here, public disclosure obligations might be mentioned, press statements, agreed press statements or releases, media protocol, something like that. Martin, your experience from investment arbitration. So how is investment mediation different in how you experienced it?
I think the advantage of investment mediation to arbitration is what Wolf mentioned, I think some minutes ago, is that you should meet in mediation at a stage where the positions are not in a very hostile atmosphere situation, because in investment arbitration, but also in other arbitrations, you see when parties are going there, and I go there with our management in charge, with people from the company, and since this is not their daily business, but there has been some time before that, and the development where things are getting more and more harsh and more direct, more uncomfortable for the people, because there are internal situations that need to be considered, like numbers, objectives that certain people and levels need to reach. So in arbitration, usually this is the very last resort. And then the situation is quite can be uncomfortable for people from the parties. The other thing is that in arbitration, this is just a very cost-intensive and time-consuming process, because usually, in particular, investment arbitration can go over several years, and you have to spend a lot of money for that. While in investment mediation, even though you take into account that you need to establish the process design, you sit together with the mediator to establish how to proceed. This can be a very efficient, effective tool compared to arbitration. And at the end, you could end up in a situation where you are able to agree with the state and the state with the investor how life is going on after that mediation. Maybe the state needs the investor in his state because it's a very valuable contribution to the state to develop certain industries, etc., etc. And it's good to have the situation and the opportunity to meet with this neutral person who is facilitating a level of communication that leads to a position where I can look forward in the future for further cooperation. And I think it's the main distinction I saw and would see.
To support that communication when lines broke down. And as you both mentioned at the beginning, the different dimensions of investment disputes, political, economic, social. That might be a good time to pick up a question that we had in the chat. If you have a non-disputing party, as we call them in the arbitration slogan, an NGO, a civil society group who wishes to participate in the ICSID arbitration rules, we have very clear requirements, criteria, when a tribunal or how the application should look, and the tribunal will decide on that after consulting with the parties. Is there such a strict criteria available in mediation? And how would the process look of determining whether and how a civil society group might come into the mediation? Maybe Wolf, you could take that.
Yeah, thank you. That's a very good question, and it's really one of the benefits of the mediation process. And again, in the process design, when you're sitting down with the parties to discuss the process that will be utilized, one of the questions to look at is really who are the stakeholders to this dispute? Who are the parties that are relevant to trying to resolve this dispute? And it may not be the formal parties to the dispute, as Frauke said. There may be peripheral interests, for example, an NGO or a community group that's directly affected by the investment. And mediation actually provides perhaps a better platform for those groups to get involved in the discussions than arbitration would allow for. And that's something obviously that has to be agreed by the parties, because mediation is a voluntary process. But where you can sit down and map out the role of these different stakeholders or interests in the dispute, and agree how they participate in the process. They may not be sitting there as the formal parties are throughout the whole process. They may just be brought in for elements that directly affect them. But it allows those interests to be heard, and it allows for those interests then to be included in the final settlement agreement. And thereby you have a much more robust settlement agreement at the end of the day that may deal with a lot of the other issues. Because as we know, particularly in investor state type situations, depending on the type of investment that is being made, it could very well affect, for example, community groups. And they will be, even from a political perspective for the state, an issue. And so if that issue can be dealt with together with the investors' concerns, then in fact the state is dealing with two problems at the same time, and they can satisfy a much larger group through a settlement agreement. And so I think—
And you get a more robust settlement.
much more, yeah. And so the versatility that mediation allows is, I think, a real benefit to it.
And that there are not predetermined criteria, as you may see in an arbitration framework, but that this can be worked out with the mediator and the parties, whether and how, what could participation look like, a written submission, attending of meetings, discussing parts of the mediation, different approaches. We're coming to the end of our webinar. Time passed quickly. One last question from your perspective as practical experience, what are mediator qualifications that you would be looking for if you select a mediator for your investment disputes? What have you done in the past?
If I may start, and Wolf, please contribute, in particular, since you have this experience of being a mediator. I think it's really key and important to have a very experienced mediator. Experienced knowing how both the investor and state to operate, what are the hurdles that each of them have to overcome to reach a settlement, and to understand their internal processes. So knowing that like in companies and investors, there are certain levels of management on the one hand that need to be digested. On the other hand, states sometimes do not have yet an own agency or department just dealing with that, and that you need to get certain ministries on board. I don't know, the Ministry of Finance, the Ministry of Foreign Affairs, etc., etc. And sometimes also in states could be that they have different interests, and to bring them together. So someone who is experienced in that, understanding the certain and different situations, I think is a very valuable asset. And plus, the mediator needs to understand, and I think this is self-explanatory, that he's not an arbitrator. He's not there to decide and tell the parties, you're right, you're not right, even though it's in confidential meetings when they are in the mediation situation. He's really the person who shall bring the parties together, and that's the key issue.
Yeah.
Thanks, Martin. Wolf?
Yeah, no, I think Martin covered a lot of the criteria. I mean, clearly, there is a knowledge of the ISDS process that has to be recognized by the mediator, in addition to normal mediation skills that the mediator should have. I would mention perhaps one other area, and Frauke, you've touched on that, and that is co-mediation. So co-mediation is where you actually have two mediators. Both mediators are involved in the mediation process, so they're both at the same level. But in investor-state mediations in particular, co-mediation is, in some circumstances, a very effective way for the mediators to work together, because those two co-mediators, and again, as Martin said, they're not rendering a decision. Both of them are facilitating the parties and assisting them to reach a resolution. And the co-mediators can be very useful here because they can have slightly different backgrounds. So one might be a lawyer, one might be an economist, which could be very useful in investor-state situations, bringing a certain type of expertise to the discussion. Somebody might be able to speak a particular language that the other one doesn't speak. There are various elements, and because these are very complex cases, usually it's also useful to have two people involved in the process. So that is something I would strongly suggest should be considered for investor-state mediations, in addition to the normal criteria for mediators, Frauke.
Thank you. Thank you both. And for that co-mediation where both are mediators, right? That's the idea. And that these co-mediators are both appointed by agreement of the parties, which is different from your typical 3-member tribunal arbitration scenario. Thank you both. This was very enjoyable for me, and I hope for our participants as well. This concludes our 4th episode, and I welcome you to register and join us for the next episode, where we will talk to state officials on January 12th at the same time. We'll discuss policies in the new EU FTAs on mediation with André von Walter. We will have Diala Jamias from Costa Rica, who will share with us some insights about Costa Rica's bilateral investment treaty providing for mandatory mediation. And we'll also chat with an experienced mediation representative who has participated in investment mediation representing a state. And with that, happy holiday season's greetings, and be well.